We're now just hours away from what could be one of the biggest changes to federal gun laws in centuries.
A federal court just delivered what legal experts are calling the most monumental blow to federal firearm registration since the New Deal, triggering a massive scramble inside the Department of Justice as an unprecedented deadline quietly expires. For 92 years, the foundational architecture of the National Firearms Act, commonly known as the NFA, has forced American gun owners through a grueling gauntlet of fingerprinting, invasive background clearances, steep financial barriers, and months of agonizing wait times just to acquire basic firearm accessories. But that entire bureaucratic fortress has just been fundamentally cracked wide open by a sweeping federal court decision handed down out of the Northern District of Texas. When United States District Judge James Wesley Hendrix issued his landmark 66-page ruling in the Consolidated Legal Battle Silencer Shop Foundation v. ATF, which also incorporated the Second Amendment Foundation-backed Jensen v.
Judge Hendrix temporarily stayed his own judgment. He stayed the enforcement of that ruling for 7 days, and that 7 days is ending today.
ATF challenge, he didn't just tinker around the edges of federal policy. He struck at the very constitutional heartbeat of the entire regulatory apparatus. To grasp the earth-shattering scale of what is unfolding right now, you have to look back at how this structural trap was originally built in 1934. When federal lawmakers originally sought to restrict items like suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons, they faced a stubborn constitutional hurdle because the federal government lacked a general police power to outright ban these tools. Their workaround was ingenious in its legislative reach. They invoked Congress's explicit constitutional authority to lay and collect taxes by slapping a steep $200 tax on the making and transfer of these specific items. The federal government justified maintaining an intrusive national registration registry as a necessary administrative companion to collect that tax revenue.
When they removed the tax stamp from $200 to $0, that effectively made the part of the NFA that requires you to register suppressors, SBRs, and SBSs irrelevant. It made it completely useless because the whole point of the NFA was to collect tax.
The United States Supreme Court blessed this arrangement decades ago, strictly on the grounds that the tax justified the tracking system. For generations, if you wanted to legally mount a sound suppressor to your firearm to protect your hearing, you had to submit to months of federal vetting, pay the $200 tax stamp, and register your personal property into a sprawling government database maintained by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, better known as the ATF. The entire house of cards began to wobble when Congress passed the sweeping legislative package known as the One Big Beautiful Bill Act, which officially zeroed out the transfer and making taxes down to $0 for suppressors, short-barreled rifles, short-barreled shotguns, and a defined group of miscellaneous firearms.
Essentially, he found that if there is no revenue, that means there is no taxing powers. The court here emphasized that an essential feature of any constitutional tax is actually raising revenue. Once Congress zeroed out the making and transfer taxes, the NFA's registration scheme lost its sole constitutional anchor.
While the public celebrated the elimination of the financial fee, the bureaucratic machinery of the ATF kept right on grinding, forcing citizens to continue submitting Form 4 applications, fingerprints, and passport photos, and making them wait months for approval on items that no longer carried any tax at all.
Back in the old days, they had an armory, and if you had to get guns, everybody went to the armory and got their guns out of the armory. We've gone way far in the other direction, away from rationality. And, we've got an irrational president, we've got an irrational Congress. We're just not going to surrender. If we get to a legal point and we lose in court, we lose in court. But I'm not going to surrender protections for people just because we're dealing with folks who are irrational.
That glaring contradiction was spotted immediately by legal strategists and civil rights organizations, including Gun Owners of America, the Second Amendment Foundation, the American Suppressor Association, and the Firearms Policy Coalition, who quickly mobilized to file targeted lawsuits. They argued a simple, devastatingly effective constitutional truth: if a tax is reduced to zero, the taxing power can no longer legally support a regulatory registration scheme built solely to collect that tax.
The rabbi I met with tonight is a plaintiff in one of them, and in it he argues that the county is violating his Second and his First Amendment rights, and also that it's prohibiting Jewish congregants from protecting themselves amid a serious rise in anti-Semitism.
Judge James Wesley Hendrix wholly agreed with that reasoning in his blockbuster opinion, writing that because the modern National Firearms Act generates zero revenue from these untaxed categories, its regulatory provisions lose their constitutional foundation and exceed Congress's enumerated powers.
Judge Hendrix concluded that once Congress eliminated the tax, the registration scheme lost its constitutional foundation. He therefore granted summary judgment to the plaintiffs and issued a permanent injunction against the enforcement of these challenge provisions, against specific provisions of the NFA for those, covered by this judgment.
Rather than halting the implementation immediately, the court issued a strategic 7-day temporary stay to give the Department of Justice a window to appeal to the Fifth Circuit Court of Appeals or request an emergency stay pending further litigation. That exact 7-day countdown clock has expired, bringing the entire firearms community to a razor-sharp edge of uncertainty and anticipation. As the hours ticked away, legal analysts, industry stakeholders, and millions of gun owners across the country monitored the federal docket for any sign of life from government attorneys. Surprisingly, as the court's business hours came to a close, reports indicated that the Department of Justice had failed to move for an extension or file a notice of emergency relief, leaving the federal legal landscape hanging in an unprecedented balance. The immediate practical fallout of this expiration is both historic and heavily nuanced, creating a massive wave of discussion across digital platforms and legal circles. Organizations like Silencer Shop and Gun Owners of America have begun posture in preparation to operationalize the court's permanent injunction, meaning that for specific protected groups, including named plaintiffs, their members, and downstream customers, the traditional months-long waiting period, the submission of Form 4 paperwork, and the entry into the Federal Registry are legally barred from being enforced by the ATF and the DOJ. Instead, eligible buyers purchasing through covered channels are looking at a streamlined over-the-counter transfer process identical to purchasing a standard hunting rifle or handgun, requiring only a standard background check before walking out the door with their property. However, legal experts and defense attorneys are urging extreme caution, emphasizing that this victory is precise and limited in its immediate scope rather than a blanket nationwide teardown. Because the federal judiciary has increasingly reined in the use of universal nationwide injunctions following recent Supreme Court precedents, Judge James Wesley Hendrix structured his order to protect the specific parties, organizations, and their immediate retail networks involved in the litigation. Major industry players like B&T USA, Palmetto State Armory, Silencerco Weapons Research, and groups backed by the National Rifle Association and the Citizens Committee for the Right to Keep and Bear Arms fall squarely under the umbrella of protection. But individuals purchasing outside those specific commercial channels still face a complex web of overlapping administrative rules. Furthermore, heavy-duty items like machine guns and destructive devices were explicitly untouched by the legislation and the ruling, retaining their $200 tax status and full NFA scrutiny. The broader political shockwaves are already echoing through federal halls as well, with dozens of lawmakers pressing executive agencies to voluntarily expand the logic of the ruling nationwide, rather than dragging American citizens through years of protracted appellate warfare. State attorneys general such as Kansas Attorney General Chris Kobach have publicly lauded the decision as a massive triumph against federal overreach, arguing that citizens have an inherent right to protect their physical health and hearing without begging federal bureaucrats for permission. Yet the fundamental question remains whether the Department of Justice will attempt a late-night emergency filing, seek an expedited panel review at the appellate level, or ultimately choose to let the judicial writing on the wall dictate a permanent retreat. As the dust settles on this historic expiration date, the entire firearms ecosystem finds itself standing in uncharted territory, watching a 92-year-old bureaucratic wall crumble piece by piece under the weight of constitutional scrutiny.
Judge also explicitly rejected the government's argument that registering individual firearms enforces the special occupational tax on firearms in those dealers. The court held that forcing extensive registration requirements onto everyday citizens to support a business tax exceeds Congress's enumerated powers, and he noted expressly that Congress cannot stretch its taxing power to mandate registration on non-tax items on private citizens.
That's it for today, folks. See you in the next video.